Okay. Good evening. Welcome everyone to the next in our series of webinar presentations by our good friends in the ALN network, the Africa Legal Network, all of which firms are members of SIPAC. I am Robert Lewis. For those of you who know me by my Chinese name, I'm Liu Lishan, and very happy to welcome all of you here. We have an outstanding set of presentations tonight focusing on Nigeria and Ghana, particularly in technology, consumer goods, and retail expansion topics. Once again, I'm very pleased to provide a brief introduction to the Africa Legal Network. As you can see, there's strong representation across the entire continent. And in my experience, all of the firms are truly outstanding, top-rated, independent law firms in each of these jurisdictions. And in almost all cases, the partners, the leading partners and the founding partners have had education and legal work experience outside of their home countries, typically including the US, UK, and Europe. And so they bring this international standard and quality of service to their home markets and couple that with their deep, extensive local knowledge and are able to provide truly international level services, but with local capability. And as you can see, ALN, and this includes all of the member firms, are very highly rated, and the network as a whole is also highly rated. So with that, I'm going to introduce now Ajibola Asolo from Aluko and Oyobode in ALN, Nigeria. So please, Ajibola, please go ahead.
Thank you very much, Robert. Hi, everyone. Good day, good afternoon, good morning. So ALN Nigeria, Lukanebode will be speaking to considerations for Chinese investors in the technology, consumer goods, and retail expansion in Nigeria. Next slide, please. Thank you so much. So I'm Ajibola Asolo. I'm a partner within the corporate commercial franchise of the firm. Speaking to the firm itself, it's one of the leading full-service commercial law firms in Nigeria with over 150 lawyers across 3 offices in the country, Lagos, Abuja, and Port Harcourt. Abuja is the Federal Capital Territory, Lagos is Commercial Nerve Center, and Port Harcourt in Rivers State is the region where crude is exported from. The firm combines in-depth knowledge of Nigeria's legal and regulatory framework with insight of its highly regarded practitioners. It's one of the largest services in the country and in the larger West Africa region. We have 5 senior advocates, which is the equivalent of what is now called the King's Council in the UK. The firm is globally recognized across various legal directories and ranks tier 1 in practically all its practice areas with cross-industry experience across banking and finance, capital markets, M&A, insurance, infrastructure, and of course, relevant to this session itself is technology. The firm has recognition across, as I said, various legal directories, some of which are outlined before you. Next slide, please, Robert. Speaking to the relevant issue, i.e. technology and ICT, today, technology and ICT is a major contributor to the GDP of the country, principally driven by the telecom sector at 17.7% and 14.4% respectively. In Nigeria today, there's over 169 million mobile subscriptions, in addition to growing broadband access across the market. a lot of the drivers in the market today are essentially propelled by three major things at this time, I would say. And the first being the growing need to regulate emerging technologies, which we see as is evidence from the recently enacted Nigeria Data Protection Act within the country, which essentially effectuates the General Application and Implementation Directive 2025, which entered into effect in September 2025. In addition to that, there is also an increasing attention being paid to the AI ecosystem in Nigeria, which is underpinned by the recent publication of the National Artificial Intelligence Strategy document in August 2024. And as part of this strategy, the federal government plans to deploy high-performing computer resources, invest in AI, hardware and software, and increase dependence on clean and sustainable energy. The objective of the federal government in this respect is to orchestrate these things. There's also been driven by the telecoms regulator, the Nigeria Communications Commission, a licensing framework for providers and international application to person services, which essentially mandates players within this space to obtain relevant licenses from the regulator. This regulatory framework has just been outlined, in addition to a new licensing framework for VAS and A2P for local messaging services. Next slide, please. Next slide, please, Robert, if you can hear me.
I've already switched it. It may not be appearing yet.
Okay, thanks.
Go back.
There was a bit of a lag. Yeah, thank you. It's fine now. It's a bit of a lag. So correlated with what I've just outlined are the most pertinent frameworks I would speak to now would be the data protection and cybersecurity framework and e-commerce fintech regime. I'll spend a bit more time on the latter, but I'll quickly highlight the former. Essentially, with the proliferation of data centers on the continent and in the country particularly, there's been concerns about data sovereignty.
Sorry, Ajibola, I think you're frozen. We've lost you.
Essentially aims to safeguard the security, transparency, and sovereignty of Nigeria's cloud ecosystem. All this policy itself has yet to be enacted. It gives a sense as to how the regulation is shaping up and evolving in this space. Now, moving quickly to e-commerce and fintech, I'm sure we all know about the AFCFTA, which enables Nigeria-based production to access preferential tariffs across the continent. Importantly, earlier in the month, Nigeria's Federal Executive Council, which is the function that essentially effectuates power at federal level, approved the ratification of the Protocol on Digital Trade, which aims to harmonize digital commerce rules across the continent. What the protocol does is it provides sets out provisions as pertains to cybersecurity standards, electronic transactions, digital payments, and consumer rights, which are key components for safeguarding, for enabling safe and seamless trade on the continent. I think the next point I'll flag under e-commerce and fintech would just be speaking broadly to the fintech environment in Nigeria. There's been a proliferation and growth of products within this space. A key example is the buy now, pay later products, which are being rolled out by players in the telecom space, in the banking space, and in the capital market space, by operators that are licensed by both the CBN, the SEC, and telecoms regulator, who roll out this product, whether it be accessing loans on your phone or via credit. And then connected to this is the growth in the number of registered digital platforms, which has resulted in a guideline that was recently issued by the Federal Competition and Consumer Protection Commission, which essentially sets out peremptory statutory and regulatory obligations that operators in that space must abide by. That regulator is the federal government agency responsible for superintending consumer protection, and also, on the other hand, deals with merger control. Or pertinent to us in this session is its consumer protection function. Next slide, please, Robert. Thank you so much. So under the broader e-commerce and fintech space, as I was saying, in Nigeria, in addition to the growth on capital advancements side of things, we've also seen a growth in what's happening with point of sale systems in the country. Essentially, what this has done is it's helped drive very, very strongly financial inclusion in Nigeria by democratizing and enhancing access to financial services. Essentially helped or helping supply financial services to people in more far-flung locations in the country, rural areas, etc. And in connection with this, the Central Bank of Nigeria recently issued guidelines on the operations of agent banking in Nigeria, which essentially aims to strengthen and enhance regulatory compliance in this area. One of the more active, I would say, fintech, broadly speaking, businesses in Nigeria is an entity of Far Eastern, I guess, inclination and or background, one of the more successful ones. Just speaking to how operators from that region see the opportunities that are existent in the market at the moment. So under the guidelines which I refer to, just to advance this issue of consumer protection, etc., financial institutions and fintechs who offer agency banking services are required to discharge a whole bunch of obligations, as I said, to safeguard consumer protection and enhance this public good of financial inclusion. There's a whole bunch of obligations that they need to abide by, but I won't go into those in detail in this session. Next slide, please. Thank you so much. So speaking very specifically to Chinese investment in Nigeria, China is one of Nigeria's foreign investors in the country. Bilateral trade between the country has just blown up in the last decade to 15 years, and China remains currently one of the continent's largest trading partners. Bilateral trade between Nigeria and China is circa $21.9 billion, which represents about 8% of the total China to Africa trade. That just gives you a sense as to how voluminous it is. And China and Nigeria share, over 50 years of diplomatic relations, with the country investing in Nigeria across multiple sectors, whether it be infrastructure and construction, financial services, mining and minerals. We've heard quite a lot about rare earth minerals very recently, automotive, steel, and agriculture and energy and power. Next slide, please. So as I've said, the Chinese are very much familiar with investing in Nigeria. Trade that's between Nigeria and China continues to grow. So the purpose here wouldn't be to encourage them to invest in Nigeria, but would be to encourage them to actually double down in Nigeria. So to that end, I will just quickly flag two case studies on how to calibrate these investments from a contractual agreement perspective, and just flag some points that Chinese investors should bear in mind in moving forward for Nigeria. So, I mean, the first pertains to an issue where there was an agreement between the Chinese Civil Engineering Construction Company and the Lagos State government, and in respect of the Lekki Free Trade Zone, essentially this had to be renegotiated because subsequently, post implementation, it was considered to be somewhat imbalanced in favor of the company. And the second is essentially the second two was similarly constructed, right? And the lessons to be taken for moving forward essentially here would be that in looking to chaperone investments into the country, there has to be early regulatory engagement via trusted legal advisors, which will see to it that investors have a clear understanding of the regulatory framework as it pertains to their intended propositions. And then the second would be, it's crucial to ensure that we clarify all the relevant data and privacy concerns in the country, because that is an area where regulatory authorities in the country are essentially rather exercised, and I don't want to use the word aggressive, but it's just something that operators in Nigeria and investors into the country do need to bear in mind. Clearly, investors need to avert their minds to issues as it pertains to foreign exchange and currency devaluation issues, just generally the regulatory environment. And you obviously have to hedge your investments on the equities and infrastructure side or capital investment side as required. And then obviously there's also, you need to avert your mind to industry regulation as it pertains to things like local content, localization, obligations, and things of that nature. Next slide, please. So speaking broadly to the regulatory landscape as it pertains to the current session, the telecom sector in Nigeria is relatively speaking up to its task, and it basically has operational licenses for relevant functions that investors may wish to discharge in Nigeria. Added to that, there are also guidelines on the technical specification relating to the deployment of infrastructure in the telecom sector in Nigeria. The provisions and the standards that are outlined in this regulatory framework do need to be, you do need to pay attention to them. And then there are specific approvals that are required depending on technical activities to be taken, what sector you're playing in. There's also a regulatory agency referred to as National Office for Technology Acquisition and Promotion, which essentially looks at things like technology transfer, etc. And broadly in this framework, there's an obligation to register technology agreements and just seeing to it that technology is transferred in a way that associated localization benefits follow accordingly. Next slide, please. I've spoken to data protection. This is a big issue in Nigeria at the moment, and I would just reiterate that with the coming into effect of the Data Protection Act General Application and Implementation Directive, the previous framework ceased to exist, and this outlines robust provisions as it pertains to obligations that data controllers and data processors in Nigeria need to avert their minds to, which obviously correlates to the next point on the implication of transfer of data. The data protection provisions, which you see in effect in the EU, at the moment is practically what exists in Nigeria as well. So investors do need to avert their minds to this. We will have heard of some of the issues that major global technology players have had recently in Nigeria on this matter. So this is something that Chinese investors do need to bear in mind as it pertains to investments in Nigeria. Similarly, the federal government has enacted the designation and protection of critical national information infrastructure order, which is aimed at protecting critical national information infrastructure. These are items as well that investors do need to avert their minds to and take appropriate legal and regulatory advice on. Next slide, please. The e-commerce framework, e-commerce legal, framework and in the fintech space is another big one. As I alluded to at the earlier part of my intervention, the fintech environment, broadly speaking, is regulated by, it's an interplay of functions of a number of regulators, the Securities and Exchange Commission, the CBN, the Consumer Protection Authority, and the telecoms operator. So all these functions are the regulatory obligations straddle as between all these regulators. So investors do need to take appropriate advice and be mindful. The regulatory regime in Nigeria aspirationally is relatively developed. So it could very well be that imperatives that might exist in the US, the UK, or Europe also exist here, and investors do have to grapple with how to discharge, how to maintain, abide by these obligations. I guess the most pertinent thing to flag here is just the most recent of these laws is the Investment and Securities Act, which pertains to the securities and capital market space. Essentially, there's been a dramatic advancement as it pertains to virtual assets, cryptocurrencies, etc. here. And in terms of development, I would just flag that the SEC is very active in this space. Added to that, the Revenue Authority too is currently doing some work in this space. The SEC has currently granted approval to two platforms, Quidax and Busha, and is currently considering other applications as well. So this just speaks to the dramatic growth in that space, dramatic development in that space. There are businesses from Asia with investments and propositions in that space. So clearly, they do need to avert their minds to the developments that's ongoing there. Next slide, please. I would also speak to the consumer protection and product liability framework in the country. At federal level, the Competition and Consumer Protection Authority is responsible for enforcing consumer protection issues in that space. But investors and businesses must also avert their minds to the fact that sectoral regulators will often have set out their own consumer protection regimes as well. So there'll be two broadly in any given space you're operating, there'll be two regimes to abide by. In fact, it could also very well be that if you operate in a state like Lagos or Abuja or Kano, etc., there could also be subnational consumer protection and product liability regimes to abide by as well. Next slide, please. So to manage time, I'll just quickly run through the IP, registration and enforcement regime in the country. As you would expect, intellectual property rights, including trademarks, patents, and copyrights, they're preserved and safeguarded in Nigeria under the relevant regulatory regimes. There is a trademarks and patents designs registry, which deals with trademarks, patents, and designs, while copyrights are dealt with by the Copyright Commission. I won't go into the specifics of this. I'll just note that the Trademark Act provides legal protection for registered trademarks, and they do have to be published. They'll typically be published as you'd find any other jurisdiction in a journal where opposition is typically advertised in the journal. The trademark is valid for 7 years and renewable for a subsequent 14-year term, while a patent is valid for 20 years from the date of filing. Next slide, please. I think the final thing I'll speak to here would just be best practices for market entry. There's been two key points to flag here, which is that you do need to pay attention to the share capital requirements, business permits, etc., all of which are outlined in something called the Handbook on Expatriate Quota Administration in Nigeria. And then we do have lots of Chinese operators who operate in FTZ zones. There are pertinent obligations for them to avert their minds to here. I think, just broadly speaking, the top level point I would flag is that there's been a raft of amendments in the tax regime in the country, which introduces some changes on the FTZ side. So operators do need to avert their minds to that and take appropriate legal advice. Next slide, please. And other considerations, I guess the most important of which is inflow of capital into Nigeria needs to be backed by something called a certificate of capital importation. I mean, a lot of our Chinese investors would be familiar with this already. It just sees to it that you're able to externalize your capital, both externalize your capital, which you inflow, and any proceeds and returns thereon. As I said, our operators would already be familiar with this. The purpose of this session from a Nigerian perspective is actually not to encourage you to invest because you invest already, but to double down even further. Thank you very much. I believe this is the last slide, but I'll stop here in any event. Thank you very much.
All right, thank you, Ajibola. I wanted to go back to your case studies here, and I just wanted to ask a couple of questions. First of all, by way of background, I've only done a few projects in Africa. I have some friends who've done a lot. And my understanding is that maybe 5 or 10 years ago and earlier, the Chinese investment in Africa, and I'm assuming it would have been this way in Nigeria, were mostly government to government. And now we've progressed now to where there's more standard commercial transactions, negotiation, both parties, et cetera. So in looking at these two case studies, if I understand that these were agreements between a Chinese company and the government, Lagos state government. In that case, I'm trying to understand, when did the issue arise that it was discovered that maybe it was imbalanced? And I'm assuming it was the government side in Lagos state that actually raised this issue. I'm just trying to understand, how did the issue arise such that it became a point of renegotiation?
In terms of specifics, I wouldn't want to mischaracterize, so I can get back on that. The You're correct about G2G. Actually, now there's G2G and G2P, private sector players. But what thematically tends to happen is that post-implementation of some of these agreements, they don't find, from the government perspective, typically subnational, they don't find certain terms disproportionately disadvantageous from their perspective. So obviously, as you can imagine, key things like creation of employment, taxes, so the taxes from personal income tax perspective, if you're not seeing the type of flows you ought to be seeing there, it would correlate to, for example, the number of local employees you have there. That was one of the driving imperatives in the second example. But it's just those kinds of things that tend to drive the subnationals looking to reopen this agreement on the Nigeria side, and that's happened now once or twice. So just thematically speaking, it's something that operators do need to be mindful of. Um, and so I guess the best way to approach this would be that in in conceptualizing and implementing these agreements, ensure that your touch point with the subnational governments is robust. Ensure that you have, um, you're leveraging your network effects artfully, just to ensure you're keeping abreast of the pulse as to what the subnationals would like to see from a tax revenue perspective, from an employment creation perspective. So you're addressing those, because that would then limit the need to actually reopen these things, implementation further down the line. I think that would be my response to that question.
All right. And one of my questions is, in these types of negotiations, will the subnational government entity, will they be represented by legal counsel, or is it government counsel or external counsel? Because these are things that I would expect they might be anticipating on their end, but you're suggesting that the Chinese side should probably be thinking about these in advance, almost on behalf of the Nigerian counterparty.
Yes, correct. Oftentimes, this point you make speaks to capacity, which is something that certain states are stronger in than others. But oftentimes, when some of these propositions come, capacity might be lacking. And then you find 5 years down the line, there's been an upgrade in capacity and understanding. And then it basically increases the scale of demands that subnationals make. But in my experience in these negotiations over the years, there's been support both oftentimes from a function internal to the government authorities. But we're seeing now that government agencies and authorities are basically exercising more recourse to external counsel, local and international, in these matters. So there's an increasing sophistication in this respect, particularly in places like Lagos, Abuja, Kaduna, and river states. These are places where you're seeing some of these projects and these negotiations happening.
All right. And I wanted to see if I could get back to this e-commerce and fintech. Obviously, Chinese online e-commerce is huge around the world, and I'm assuming it has a very strong presence there. And fintech, of course, as you say, there's a lot of Chinese and other Asian operators that are active in this space. I just wondered, are there any examples of Chinese participants in these sectors that you see as being quite successful in Nigeria?
Yes, actually, yes. So there's there is there's entity called OPE
Hmm.
in Nigeria, which is quite successful, and has basically chaperoned positive disruption across various components in the value chain in the fintech space. There are also lesser known entities who I would say operate in fragments and silos across the lending space. So whether it be from telecoms perspective or even from the CBN regulator space as well. So there are positively disruptive Chinese elements across the value chain, but I've just mentioned one big one in the country.
And it seems to me that this is, as you've described here on this slide, this is an area of focus for government regulation. And so this is an area where the players in this sector will have to keep on top of the ever-changing regulatory environment, I would assume.
Yes, yes, exactly correct. Because from a policymaking perspective, the regulators and the government agencies, I'm sure they find that um, these businesses or these functions are actually a very effective way to democratize, um, the financial inclusion and just the extension of financial services to to people in far more remote locations. I would say in places like Nigeria, Ghana, etc. So they are paying attention to that space. It's also a space that's been because of the quick pace of innovation. There have been issues in that space. A bit of let me just say there's been some issues in that space. So the CBN is always issuing regulations, guidelines, just to ensure that they stay on top of developments in that space. It's a space that the federal government likes because, as I said, it helps advance this issue of extension of financial services to rural areas.
All right. Well, thanks so much for your excellent presentation. We'll move now to our friends from Ghana. And so we
Thank you so
have
much.
Achia and this is Gwenda. If I have it right here, it's partially blocked on my screen here. But let's see, I'm not sure which of you is going to go first, but I'll turn it over to you. You can introduce yourselves and your firm and just tell me when I need to move to the next slide.
Thanks, Robert. So I'm HR Deborah. I'm a partner at the law firm of Endon and Company, ALN Ghana. And with me today, doing the presentation for the Ghana piece is my partner, Wendy Bannerman, who will also have an opportunity to introduce herself later on in the presentation. Next slide, please. Okay, so today we are looking at the key legal and regulatory considerations for Chinese investors entering Ghana's digital and technology markets. We'll be looking at relevant issues relating to e-commerce, telecommunications, ICT regulation, fintech regulation, consumer protection. We'll touch on intellectual property rights protection, data protection, and briefly on cybersecurity as well. Now, these different regimes collectively shape the country's digital business environment, and knowledge in these areas is central to ensuring lawful market entry and mitigating regulatory risk and supporting sustainable growth. So we hope to provide participants on today's webinar with practical steps for aligning investments and operational models with Ghana's regulatory framework. We will delve into e-commerce first. So currently, there are very attractive conditions for technology-driven retail and consumer goods protection expansion in Ghana. Our GDP growth is among the highest in the sub-region. We've had some troubles with our currency in recent times, but we are experiencing some currency reforms and through IMF-backed fiscal measures, as well as different measures that are being introduced by the new government. There is an expanding digital economy with a mobile penetration of about over 125%, growing consumer spending on electronics, home appliances, and fast-moving consumer goods. Coupled with a young population, a young tech-savvy population, this creates attractive conditions for expansion in e-commerce. So taking a look briefly at the legal and regulatory framework supporting e-commerce activities in Ghana, we have the Companies Act, the Ghana Investment Promotion Center Act, Electronic Transactions Act, and some additional ones listed on here, which we will take some time to look at in due course. Next slide, please. I'll take a brief look at each of the different laws and highlight maybe some important considerations for Chinese investors looking to establish their businesses in Ghana. And we'll begin with the Electronic Transactions Act. This provides the framework for electronic transactions. It ensures the validity and enforceability of contracts that are negotiated and concluded online. and basically gives validity to different issues relating to electronic contracts, electronic messages, and electronic records. In addition to these different legal recognition that the Electronic Transactions Act provides, there are concrete obligations for companies that engage in e-commerce business in the country. These include the imposition of various refund and delivery obligations. There are some consumer-focused requirements that ensure that consumers have a right to either cancel purchases and require a full refund, and also entitles them to a full disclosure of company and product information. Then, of course, there's a data protection and confidentiality obligations that are imposed on companies that transact with Ghanaian-based users. Next slide, please. In terms of data protection, I will just touch briefly on this as Wendy will take a deeper dive into that later on in the presentation. But what it does in the e-commerce space is it ensures that personal data that is collected by businesses are used and processed lawfully and securely. Businesses that are recognized as data controllers are required to register with the Data Protection Commission. And there are different obligations that ensure that consumers' data is protected and they have a right to access same. Next slide, please. The Payment Systems and Services Act regulates digital and mobile payments through licensed providers in Ghana. So what's important to note here is that for businesses that are operating in Ghana, they need to ensure that they partner with duly licensed entities and that they ensure that they are abiding with the different regulatory obligations that are imposed on them under the Payment Systems and Services Act. That Act also provides several redress options for consumers who encounter issues in transactions that are undertaken online. Next slide, please. Another important legislation is the Ghana Investment Promotion Center Act, which governs local and foreign investment in Ghana's business sectors. There are different capital thresholds for foreign participants in Ghanaian businesses. And so if a Chinese investor is seeking to establish a subsidiary in Ghana, they are required to abide by these minimum capital thresholds. I'm sure our listeners today would be very familiar with some of these requirements. But for the retail sector, what's important to note that under the GIPC Act, you are required to bring in a minimum capital of $1 million US, and you're also required to employ at least 20 skilled Ghanaians in your enterprise in order to be eligible to register with a center. And registration with a center is important for various reasons. It affects how you're able to transfer or repatriate dividends and profits out of the country. And so if you're not compliant with this very important piece of regulation, you may face some difficulty in sending funds back home. Finally, I will touch on the GRA e-commerce practice note, which basically clarifies the tax obligations for online and digital businesses. Now, this regulatory this regulation is important because it has some extraterritorial effects. So ordinarily, you would anticipate that companies that are either incorporated in Ghana or have some of residence in Ghana or some permanent establishment in the country will be subject to our tax laws. However, under this piece of regulation, it seeks to tax businesses that are not physically present in Ghana, but provide certain online and digital services. And it imposes some registration obligations on them to enable them charge VAT and collect same and remit this to the Ghana Revenue Authority. So for Chinese e-commerce players, this is a very important piece of legislation, as you would be required to comply with it or face the full sanctions of the law. Next slide, please. So over here, we attempted to put together a short compliance checklist for companies that seek to enter the Ghanaian market. First of all, I think you just need to decide if you intend to have an actual physical presence in Ghana, which would require you to register with the Office of the Registrar of Companies, either as either registered subsidiary or a branch office. And then once you do register with the ORC, you're also required to register with the GIPC and meet the different obligations that I mentioned earlier on. In terms of the tax and fiscal compliance obligations, as I said, even if you do not intend to have an actual physical presence in Ghana and all your presence will be online, there may still be some obligation to register for VAT purposes with the GRA if you're deemed to be providing digital services to Ghanaian consumers. Next slide, please. In order to ensure compliance with the various obligations under the Electronic Transactions Act, as well as the Data Protection Act and the Payment Systems and Services Act, we would advise that you fully disclose, you provide the mechanisms that are able to disclose different product information and seller information to consumers. You provide them with the requisite 14-day period within which they can decide to cancel a transaction or to conclude it. And also under the Data Protection Act, you would be required to register as a data controller, obtain consent from consumers before collecting and processing consumer data, as well as ensuring that your systems are secure and encrypted to ensure data security. As I mentioned earlier, you need to ensure that you partner with only licensed payment services providers and that you have robust AML and KYC compliance systems. Next slide, please. And that leads us into the fintech regulatory landscape in Ghana. Currently, we have 59 approved entities across a broad range of different licensing categories. The majority of them are PSP enhanced license holders. We will take a look later in the presentation at what these entities are permitted to do, what activities that they are authorized to engage in. But about 71% of the current players hold this particular license. Ghana has recorded 576 billion Ghana cedis in terms of transaction value in the sector. There's been over 70% growth, and more than 20 million individuals are registered to enjoy such digital products within the fintech landscape. Next slide, please. The key regulators in the fintech sector are the Bank of Ghana, which issues licenses to different different service providers, depending on the nature of the activities that they want to engage in. There's a Financial Intelligence Center, which oversees the AML and CFT compliance regime for licensed entities. There's the Securities and Exchange Commission, which is relevant where such fintech companies issue securities or any token-based instruments to the public, which would fall under the purview of the SEC. And there are other regulators such as the GRA, the National Information Technology Authority, the GIPC, and the like, depending on the nature of the activity of the specific company. Next slide, please. The Bank of Ghana's licensing framework for the fintech sector looks at 6 different areas. There's the dedicated electronic money issuer, the payment service provider scheme, the payments service provider enhanced, the payment service provider medium, and the payment service provider standard, as well as the payments and financial technology service provider license. Now, to be able to operate within Ghana's payment sector, you need to hold a license under one of these categories or partner with a duly licensed entity to perform the regulated activities on your behalf. Next slide, please. So on this slide, we highlight the different activities that licensed entities may undertake based on their operating model. And I will not go into too much detail in here, except to perhaps say that for the payment and financial technology service provider license, sometimes it is not immediately apparent that an entity may require that license because they are usually found at the back end of operations. And so it's always recommended that you speak to legal advisors who have a good sense and appreciation of the regulatory requirements in this area to enable you to understand whether a license is required for your proposed activities. Next slide, please. There are different minimum capital requirements that are imposed on the different license categories that I've just spoken about. And these range between 500,000 cedis and 20 million Ghana cedis, depending on the category of license that you hold. There are different fees, processing fees, license fees, and renewal fees that are payable for the different license categories, and the license is typically valid for 5 years. Next slide, please. As I indicated earlier, there are 2 pathways to enable you operate within the fintech landscape, the payments landscape in Ghana. You either incorporate a local entity and apply for a license from the Bank of Ghana, or you partner with a licensed entity which provides a regulated service to you and ensures that you remain compliant under Ghanaian law. Typically, there are some entry barriers for foreign investors seeking to enter the Ghanaian payments system. And it's usually in relation to the 30% local shareholding requirement that is imposed under the Payment Systems and Services Act. Understandably, this can be a challenge for investors because it may be difficult finding the right partner, and you need to decide whether you are partnering with this person for strategic reasons, or you want them to be an active participant in the business. And so there are different considerations that come to play when you decide to partner with a Ghanaian entity and offer them 30% of your business. It's always important, as I said earlier, to speak to people who understand the regulations and the legal framework to provide you with the relevant advice on how to structure your investments so that you remain compliant with the required rules. There are also fit and proper governance requirements for key management personnel and directors on the board of the local entity. And it's important that you look at these areas to ensure that your application for a license is not rejected. Okay. Now, in terms of registered entities, there are different compliance obligations, and I've mentioned a few of them already. Maintaining the minimum capital requirement that is set by the Bank of Ghana for the specific category that you're applying to operate in. Having a board of directors with a minimum of 3, 2 of which will be resident in Ghana, adhering to KYC and AML requirements, ensuring consumer protection and transparent pricing in your operations, and implementing various safeguards under the Data Protection Act. Next slide, please. I have already mentioned some of these issues, but this slide highlights the key commercial issues that you may expect to face as you seek to establish operations in Ghana's payment sector. So you need to think about your equity structure and who you partner with. The ultimate beneficial ownership requirements are quite stringent, and so you need to provide proof of who the ultimate beneficial owner of the business is, with notarized attestations of all relevant documents. You need to ensure there's local management and a properly functioning board in place. You need to have a physical presence in Ghana if you seek to obtain a license in the payment sector. Typically, we have people trying to do payments businesses or operate a payments business from outside Ghana. But one of the very relevant requirements of the Bank of Ghana is that you should have physical presence in the country and your operations should have substance. You need to think about the partnerships, again, that you would want to have with various commercial players, and all these need to be approved by the Bank of Ghana. Finally, you need to think about the impacts that delays in the licensing procedure can have on your plans and operations to launch within a specific period. So it's always good to prepare ahead of time, know what the obligations are, and then try to roll out a plan that helps you achieve these objectives. Next slide, please. I've already spoken about the digital service tax on non-resident digital service providers, as well as the GIPC's requirements for foreign investors. So I'll probably touch briefly on the enforcement mechanisms and penalties that are applicable to companies that fail to comply with the relevant regulations. There are strict penalties, including criminal sanctions that are imposed on willful breaches of the relevant legislations under the AML Act, the Data Protection Act, as well as the Payment Systems and Service Providers Act. Recently, the Bank of Ghana has taken enforcement action against several companies for regulatory breaches in the remittance business. These include Flutterwave, Cellulant, and TapTap Send, who flouted various requirements relating to the foreign exchange regulations and exchange control provisions. We've even had partners of PSPs also facing some sanctions, such as the United Bank for Africa. Next slide, please. All right, so in order to ensure compliance with the various regulatory obligations that I have just provided, you need to decide on your relevant corporate vehicle. If you decide to register in Ghana and not partner with a licensed entity to provide a regulated service, you need to incorporate a subsidiary and register with the GIPC after satisfying the minimum capital requirements. You need to provide 30% of your equity to a Ghanaian citizen, and You prepare the relevant applications for your Bank of Ghana license, which would require you to register with the Data Protection Commission and to build robust KYC and AML systems for compliance with your AML obligations. And you will also need to complete your registrations with the revenue authorities. One key issue to note as you decide who you partner with is that nominee shareholder arrangements are not something that we would find acceptable under our current regulatory framework. And so your partnership with the local citizen, with the local company should have substance. They should have economic rights to participate in the dividends of the company. They should have voting rights and all the regular, typical rights that are associated with shareholding in a company. Secondly, what we have seen in practice is that a lot of companies underestimate the timelines in relation to launching their operations in Ghana as a result of the delays that are frequently encountered in the licensing process. And so we always advise that you build a lot of flexibility into your timelines and also prepare adequately so that once you submit the application, there are fewer interruptions and interrogations from the regulator that enables you to have a smooth licensing process towards getting your license. Next slide, please. Okay, so I think I will move on to the telecommunications regulatory framework and conclude with consumer protection rights before my partner Wendy takes over to do the data protection aspects and intellectual property rights aspects of the presentation. The technology market is rapidly expanding. Currently, recently, Ghana launched the 5G network, which is a state-backed infrastructure. It involves a state-backed infrastructure company, NextGen Infraco, and it holds an exclusive 10-year 5G license, and they are required to launch by the Q4 of 2025, or else face different sanctions by the regulator. There is a merger between AT Ghana and Telecel Ghana, which are two of the three dominant telecommunications network providers in Ghana. There is a planned investment of about $150 million in the Ghanaian telecom sector. In terms of the legal and regulatory framework, the government is introducing an industrial property bill, which will seek to set up an industrial property office to help regulate and register various industrial property rights. And Ghana has recently unveiled a number of digital and technology-related bills in a bid to set up a digital and digitalization hub in the country. These laws are currently before Parliament, and we expect that by the middle of next year, they would have been passed and provided the relevant regulatory support for the digital transformation agenda. Next slide, please. Next slide, please.
There must be a lag. I'll go back. Can you see it now?
I can see that now. Thank you, Robert. So as of February 2024, there were about 1,010 sites built under the Ghana Rural Telephony and Digital Inclusion Project, which is a good example of the Ghanaian and Chinese cooperation in the telecommunications sector. Ghana and China have also agreed to finalize a 0% tariff agreement, which would make Ghana only the second country in Africa to enjoy such a deal. It was due to be signed on October 20, 8th of this year, but we understand that that has not yet happened, and the parties are close to reaching an agreement. There's an MOU for technology transfer that was signed between Ghana's Votal Regional Coordinating Council and the Chinese Belt and Road Environmental Technology Exchange and Transfer Center, focusing on green tech transfer and investments. Next slide, please. We'll now take a look at the regulatory framework, which is supported by the Electronic Communications Act, the National Communications Authority Act, the National Communications Authority Regulations. There's the Data Protection Act, the Cybersecurity Act, and the Electronic Transactions Act. Next slide, please. So there are various different sectors for operating within Ghana's telecommunications sector. And depending on the nature of the activities that the investor intends to engage in, you'd be required to make the appropriate application for the appropriate license. These include mobile cellular, fixed network license, virtual network operators license. There's the infrastructure license, microwave authorizations, and a host of others. Next slide, please. There are various licensing requirements as well for importers or manufacturers of electronic products, and these are regulated under the type approval guidelines. What these require is for the relevant company to apply for approval from the National Communications Authority and ensure that the various standards that the authority sets can be found within the product in respect of which they are seeking approval for. There is also the Digital Territorial Television Conformance certification, as well as various licensing requirements for the infrastructure license. Next slide, please. There are various local content requirements ranging between 30% to 70%, depending on the nature of the activity that you want to engage in. And we've provided a brief overview of the licensing process for the different license applications on this slide, which you can take a look at later on. Next slide, please. Consumer protection. Currently, Ghana does not have a single framework, a unified framework for ensuring consumer protection rights. Rather, the different protections are scattered across different laws. And so in order to ensure that you're compliant with the various obligations that are imposed under Ghanaian law for the different activities that you engage in, investors are encouraged to have a broad overview and to speak to knowledgeable advisors who can advise you on the various regulations. Next slide, please. There's a consumer protection bill, which was first introduced in 2006, but is yet to be enacted. It's still before our parliament. What it seeks to do is to unify consumer rights and provide a comprehensive framework for strengthening enforcement mechanisms in the area of consumer protection. Key features of the consumer protection bill include the product recall powers, and unfair trade prohibitions, redress mechanisms, and consumer education duties that are imposed on service providers. Next slide, please. There is a consumer protection policy framework that currently fills the gap. It was developed by the Ministry of Trade and Industry in 2022 to guide the reform in this sector. It outlines the various principles for ensuring consumer protection and defines the core themes, which include product safety, fair trading, truthful advertising, redress systems, and digital commerce governance. It coordinates the efforts of the different sector players, including the Ghana, including the Food and Drugs Authority, the National Communications Authority, and the Consumer Protection Agency, as well as the Ghana Standards Authority, to improve consumer trust and reduce market abuse. And it encourages interagency cooperation and the adoption of global best practices. Next slide, please. As I mentioned earlier, so currently, because we do not have a comprehensive legislation for consumer protection, the different regulatory obligations are scattered across different acts, including the Public Health Act, the Ghana Standards Authority Act, the Sale of Goods Act, and the PURC Act. Next slide, please. Under the Electronic Transactions Act, there are various consumer protection obligations, such as the right that is afforded consumers to cancel a transaction within a 7 to 14-day window and to demand a full refund of their funds. Next slide, please. The Data Protection Act focuses on the privacy aspects of consumer protection, and it ensures that data subjects are provided access to their data that is collected by businesses in the provision of various consumer services. It goes beyond the product or service itself, the consumer's personal data, personal identification data, and information. And it ensures that personal data that is collected is handled lawfully, fairly, and securely. Next slide, please. Due to the lack of a comprehensive framework, there is some fragmented enforcement. Different agencies typically flex their muscles in a bid to ensure compliance with the various obligations under the different laws. There's also limited awareness, as many consumers are not aware of the rights that they have under these different compliance channels. There may also be judicial delays in redressing consumer complaints, which discourages enforcement of such rights by consumers. Next slide, please. I'll now hand over to Wendy to proceed with the data protection and cybersecurity regulatory regime. Thank you.
Well, hello, everyone. My name is Wendy Bannerman, and I'm partner in charge of dispute resolution, which includes litigation and arbitration at end-owner and company ALN Ghana. And I also have oversight responsibility for the data protection and intellectual property practice areas. So I'll be speaking to you today on data protection and cybersecurity, and also intellectual property. So my colleague Echan gave us some good, next slide, gave us some good statistics on the fintech revolution in Ghana. Mobile money revolution in the last few years has been really rapid. Anecdotally, I think Ghana may be processing more mobile money transactions than bank transactions, probably compared to China's Alipay or WeChat Pay. We also have a young tech-savvy population. I think the key question we need to ask is, how do we balance innovation with privacy protection, especially when it involves data protection? So I'll talk about some key legal considerations for data protection and cybersecurity, which will help investors seeking to enter the Ghanaian market. I mean, this will help with lawful market entry. It will mitigate regulatory risk and support the sustainable growth of businesses. So in terms of the key legislation, we have the Data Protection Act. I think we were ahead of the curve, and I'm only comparing to Nigeria, when our law was enacted some 13 years ago in 2012. We have a Data Protection Commission, which was established then and is acting now to enforce the provisions of the Act. But there's currently a draft bill seeking to replace this current Act. And the key expectation is that this commission will be changed to an authority because it wants to increase its enforcement powers. That's why, I think that we should just spend some time understanding what the basic requirements of this act is. So as a data controller, you have to register with the Data Protection Commission. And you would ask, who is a data controller? So a data controller is any person who collects data and determines the purposes for which the data must be used. What we always say to our clients, entry market clients, is this is typically everybody who wants to do business in Ghana. Because even if you have one employee and you're collecting the name, email address, or any form of personal data, you will have to register as a data controller. The entity that processes the data on behalf of the data controller need not register with the Data Protection Commission, but that entity also has the same compliance obligation as pertains to the data controller. So basically, the Act controls how data is collected, retained, processed, to safeguard against data breaches and unsanctioned use of data collected. So I'm going to talk a bit about the scope of the Act, because it doesn't apply to just data that's processed locally, but it also has some extraterritorial application. So where the data originates partly from Ghana or partly from some foreign entity, but relates to Ghanaian data subjects, the Act will apply. In terms of foreign data, the law requires that where there's a foreign data subject in Ghana, there are double data compliance requirements. So a data controller or a data processor will have to comply with the laws that pertains to the foreign jurisdiction where that data subject is coming from, and then also comply with the Ghanaian law. So assuming we have a Chinese data controller who enters our market but processes some of the data externally and processes some of the data internally and has some Chinese nationals who are resident in the country, the obligation to comply with the data protection requirements would apply based on China's data protection laws and Ghana's data protection laws. Data which merely transits through Ghana, so it just passes through Ghana, but it doesn't necessarily go through any form of processing, is not regulated. Currently, it is not regulated. Data I'll talk a bit about data localization as well. So under our Act, data localization is also not regulated. So there's no specific requirement that if you are processing some specific data relating to Ghanaian subjects, you must necessarily do it within Ghana or use systems that are local. So the essence of this is you can process data outside on any system, but you just have to comply with the provisions of the Act. As I mentioned, there's a bill before Parliament, and the bill has certain recommendations. One of the key expectations is that there will be some form of regulation on data localization. What this means is some categories of sensitive or special data will be expected to be processed or kept locally. They're yet to flesh out those portions of the laws, and once we're aware of it, we will update you. The current provision on foreign companies who intend to process Ghanaian data is that you must necessarily register in country. So you have to either incorporate a company or register as an external company. We noticed that this, particularly for some of the clients that we've had opportunity to advise on, some of them, are a bit uncomfortable with this position because they're not necessarily doing business in Ghana, but they are processing data that relates to Ghanaian subjects. And the whole rigor of going through an incorporation process, is not, they're not comfortable with that process. Unfortunately, the law now is you have to register as an external company or incorporate. But we've noticed that the new bill has taken away this requirement. So even though you won't be registered in Ghana, you will still have to comply with the law. I think this will be a welcome change to a lot of investors who want to enter into our market. Next slide, please. Okay. So where you have to process data, I mean, these key principles, anybody, and I don't think this differs from Nigeria or from China or from any other EU state, you have to process the data in accordance with certain key principles. This is like basic. So you have to ensure that the data that you're collecting is lawful and it's fair. This is where the consent requirement comes in, where you're seeking consent from a data subject. You have to ensure that the consent has been given freely. So in the new bill, what will actually be required is that not only must the consent be clear, it must be written, it must be free, it must be explicit, and it must be informed. So this puts an additional burden on the data controller or the data processor to ensure that where you're obtaining consent, you're complying with this requirement. When there's an issue, they would come back to the source of the consent and they would gather, they would go through those consents in line with these principles as I'm sharing them. So the purpose limitation, you only have to ensure that you're collecting data for a specific or legitimate purpose. Data minimization, you have to ensure that the data that you collect is not excessive. It has to be just right for the purpose for which it's required. The data has to be accurate, it has to be up to date. In terms of retention limitation, every data controller must have a retention policy. If we don't remember anything, we need to remember this. So the retention policy ensures that you're clear about how long the data is going to be kept. You're clear about what happens when the data is within your possession and what happens when that period lapses. So you should have a retention policy. As I speak today, it is not a legal requirement, but when the bill is introduced, they would put this in there as a specific legal requirement. But it's a good practice for you to have this. And sometimes the Data Protection Commission looks at this when you're seeking to renew your license and they're looking at your data compliance. They would want to see that indeed you have a data retention policy. So in terms of security safeguards, you also have to use appropriate technology and organizational measures to ensure that the data that you're collecting is being kept safely. So currently, the law does not prescribe a minimum standard that if you're doing this, these are the technology safeguards that you have to comply with. But typically what you should have is, you should have a privacy statement. You should know how you're pseudonymizing and encrypting data. If there are certain industry standards for data protection within the sector where you're operating, just make sure that you're complying with those industry standards. Having a data protection impact assessment done on your organization, is a key requirement. You have to, as I said, it's not the law now, but it's going to be the law once this bill is passed into law. And it's essential that you have that so that you can assess what the risks are, and then you can recommend some mitigation measures. You also have to do what we call a CIA. So you look at the confidentiality, integrity, and availability of your data systems. You also have to look at some business continuity measures, look at ISO standards and compliance. In terms of transparency, you should always inform the data subjects of their rights. Their rights are quite, they're basic. We have indicated them there, but they should be aware of their rights. And when there's a breach, there are notification requirements. So you should know this and make sure that you're notifying them when the breach occurs. So on the other side of the slide, we have indicated what the rights of the data subjects are, and it's quite easy for you to read and understand, but we want, data subjects have a right to access all the information, they can object to processing, they can give you the right to process, and then later on withdraw that consent for the processing to be done. Next slide, please. Okay. So I'll talk about the obligation of data controllers and data processors. I think I started with registration with the Data Protection Commission because as the Data Protection Commission will say, that is the law. Everybody, you must comply with it once you're collecting data. And then once you do this, you would have to renew that registration every 2 years. The current provision in the bill is that this would have to be done annually. So we make the life of our investing clients quite easy. when you come to us and you do the market entry analysis and what have you, and we help you with your incorporation, as soon as we do that, we go ahead and help you register with the Data Protection Commission. So we've noted on here that the registration must be done within 20 days of the start of the business. But if you speak to us, we're able to do that in a really seamless fashion. I think I've spoken about obtaining consent before you collect and before you process personal data as a data controller, and then also notifying individuals of the purpose for the data collection. I'll spend a bit of time on cross-border transfers. So where you're a data controller or a data processor and you're transferring data across borders, you have to ensure that wherever you are transferring that data to, there's some, the country has adequate data protection laws or, the rules in place to govern the data that's being transferred. So that's the adequacy principle. If the country does not have that requirement, then you know that as a data controller or processor, you know that you have the added responsibility to ensure that the data that you have sent across the border is protected. Because if it's not, you are responsible for any breach in relation to that data. I think there are very few, but there's an adequacy list with some countries on it. There are very few countries. I need to check when it was updated, but you have countries like Canada, Switzerland, and New Zealand on that adequacy principle list. In terms of appointing a data protection officer, it's a requirement for a data controller or a data controller to have a data protection officer. That person must be certified. So you go through a training process with the Data Protection Commission. You're certified, and then you are responsible for data compliance within the organization. But as we always say, it's good to have a data protection officer, but when you come in, you have to make sure that your senior management and the tone at the top must be right. So everybody has a buy-in for meeting these data protection requirements. Next slide, please. Okay, so we've put in some data. I'm not going to go through this data, but we have provided, because we're going to share the slides with you, I've put in some data which shows what the registration process entails. But as I said, you don't even have to bother yourself too much about it. We will always give you that assistance to ensure that you comply with the law. Next slide, please. Okay, mandatory notification obligations. So when a data breach occurs, the requirement is for the data controller or the data processor to take almost immediate action to notify the Data Protection Commission. And in addition to that, to notify the data subjects whose data have been breached. The requirement to notify will not be necessary if the Data Protection Commission actually tells you that, don't do it, because if you do it, it will impede some investigation that we're undertaking. So you would always have to, work with the Data Protection Commission when there's a breach. Even though the law now says that you have to do the report within a reasonable time, the expectation is as soon as it occurs and you're aware of it, you should do it. But in the bill, they've put in, they're going to include some timelines, which I think is between 48, and with the latest period being about 72 hours. If you notice there's a data breach, immediately you have to take steps to notify the Data Protection Commission. And then you would also have to put in some mitigation recommendations. But as I said, once you do the notification, the Data Protection Commission will work with you to ensure that the right thing is done, the integrity of your system is restored, and they'll conduct their own audits and then take whatever action they need to take. But as a data controller or processor, you need to keep all your records, carefully, and I'll explain why. Next steps, please. Next slide, sorry. Okay, so I'll talk a bit about the enforcement power of the Data Protection Commission. So the Commission has extensive investigative and enforcement powers under the Act. So basically, they can issue like punitive administrative fines. They can also engage, in some criminal prosecution if they notice that you've acted willfully as a data controller. And also you can, the data subject can take you to court and there will be a civil claim for damages and then compensation and legal costs. It can be really, really expensive. And our courts now are moving towards giving like really punitive damages for breach of personal data. Just recently, in terms of action that has been taken in Ghana, I think in 2023, some companies were actually, or the directors of certain companies were arrested. Unfortunately, it included a Chinese company, Huawei, for failing to register with the Data Protection Commission. That's why I started my presentation with the registration requirements. That's a non-negotiable. Every company that processes data must register with the Data Protection Commission. And then recently, the Data Protection Commission has also issued an investigative notice against the health service company for potential breach of patient data. And we're all looking to see what would happen with that. But typically, if they issue an investigative notice, the focus is on data storage. They're looking at what you did in terms of data storage, and that's why your retention policy is necessary. That's why your data protection impact assessment reports are necessary. And then they're going to check your access control for lawful processing, retention, and security, and how you upheld the rights of the data subjects. In terms of enforcement, it's a bit of a challenge. I mean, the Data Protection Commission is not enforcing in a robust way as they expected. And I think sometimes it has to do with a capacity issue because it has to be like a nationwide type of enforcement. But as I said, they are looking to become an authority. And once they do, they will definitely, I'm sure they're going to increase their capacity. They're going to be doing spot checks on companies, and it's a real hassle if you don't comply with data protection regulations. Okay, I think the key, next slide, sorry. So we've done a dashboard which shows basically what needs to be done by or what needs to be done to meet legal compliance for data protection purposes. And I've explained everything on here has been explained. So if you in your spare time, you can just go through it and just familiarize yourself with what we've said. But the key ones are the registration, making sure that you have the right policies in place. You can get a subject matter expert to help you with putting in place the right policies. They would align it with the legal requirements, and then it helps you when it comes to monitoring it for enforcement. Okay. Next slide, please. Okay, next slide. Okay. So October was a really busy month for Ghana in terms of cybersecurity. It was actually Cybersecurity Month. It was celebrated under the broad theme of building a safe, informed, and accountable digital space. And then in addition to that, Ghana, just like China, also prioritized its international commitment towards prevention and prosecution of cybercrime in the digital transformation ecosystem by signing the recent Hanoi Convention. So this is the UN Convention Against Cybercrime. 71 other countries signed on to it to show commitment to digital safety. And the key benefits we expect from being part of such a group is so that there will be clear safeguards for data protection. It always helps if the best practices across the member states. There would also be mutual legal assistance. And when this occurs, it means that if you have to, engage in extradition processes and cross-border investigations, it's quite easy to do that with all the 71 member states. It's not an issue, but Ghana is a dualist state. So what this means is, even though we've signed the treaty, for it to be binding, it has to be incorporated in our domestic laws through an act of parliament. So there are processes that we expect for enforcement. So I'll talk a bit about I've spoken about the Data Protection Act, so I'm not going to focus on that because we're limited, for time. I'll talk about the Cybersecurity Act, which is the main, cybersecurity law in Ghana. In terms of enforcement, we've listed the entities that typically would enforce cybersecurity-related activities. So we have the Cybersecurity Authority, which is responsible for licensing, incident reporting, protection of critical information infrastructure, accreditation of providers, and then enforcement of fines. Some of the sector regulators, as my colleague HR mentioned, Bank of Ghana, Securities and Exchange Commission, they also issue several sectoral directives, and they would require additional reporting and controls, audits, incident reporting. So you would have to comply with, their laws and those specific sector-related laws on cybersecurity, in addition to the Cybersecurity Act. Next slide, please. Okay, so we've talked about the Cybersecurity Act and the fact that the Cybersecurity Authority is responsible for licensing. What we have provided on this slide is the entities whose activities must be licensed. So if you're a cybersecurity service provider, you must be licensed by the Cybersecurity Authority. If you're a cybersecurity establishment, you must be licensed. And then if you're a cybersecurity professional, you must be licensed. These are key requirements. The license, when they're giving, are not transferable, and they are also typically valid for 2 years, after which they must be renewed. We have given you some guidance on what the services are, so that you can match the services against the regulated activity to see whether you need to be licensed. Next slide, please. We have also included here what the procedure for licensing is. But as I said, we always guide our clients through any licensing applications. So if you in your spare time, you go through the information and you require additional information, just reach out to us and we're going to help you through the entire process. Next slide, please. Okay. So I spoke briefly about critical information infrastructure. This is key, so I'll spend a bit of time on it. So where a computer system, where a computer, just like Nigeria, because Ajibola mentioned the CII requirements as well for Nigeria. So where a computer system or network is designated by the Minister of Communication as a critical information infrastructure, it must be registered. And they would typically designate it as such if that system or network is essential to national security or the economic or social well-being. So what happens is the ministry would issue some gazette notification indicating certain sectors that must be registered as critical information sectors. And then once it's registered, I think it goes beyond that step to actually notify entities who need to register. So once you're identified as being a part of either the telecom sector, banking and finance, national security, intelligence sectors, all of these are designated CII sectors. You must necessarily register with the Cybersecurity Authority. In terms of the obligations of CII, so organizations that own CII, you have to, one, the key one is registering with the Cybersecurity Authority. When you're registered, you'll be given certain directives which have to be followed. If an incident occurs, you have to ensure that you're reporting on that incident within maximum 24 hours of detection, because they are critical assets. So you have to make sure that you're reporting within 24 hours of detection. You also have to have a robust cybersecurity policy, not just have it, but have somebody who's monitoring it to ensure compliance. And then you also need an accountable person who has responsibility to ensure that there's compliance. There should be audit processes embedded in your system and the way you're operating your company. Access controls are important because, as I said, this is a special kind of data. So access controls are important. So in your policy, you should have some directives on access control. And then the security measures, we've spoken a bit about it. You have to ensure that there are enough cybersecurity measures to mitigate against cyber risk. And then, of course, you need to catalog all of the CII assets. Next slide, please. Okay, so data retention, the law requires that certain types of data must be kept for particular periods. We've put the information out there. So all of this will be relevant when you're putting together your retention policy. So this is not just the act that you refer to. You're going to refer to the Anti-Money Laundering Act. You're going to refer to certain acts that include like specific periods that data must be kept. So, it's good that you're aware of this information. In terms of penalties, administrative punitive sanctions for non-compliance with the Cybersecurity Act. And then also there are criminal sanctions. Normally, offenses that are committed, you're either going to pay the fine, or you're either going to be committed to a prison term. It's normally a misdemeanor, and it ranges for up to about 3 years. But if you're a director or officer of the company, you could be criminally liable just for failing to comply with these cybersecurity requirements. So in terms of suspension activities as well, so unlicensed cybersecurity entities will be barred from operating in Ghana. And very soon, we have a Minister of Communications who's bent on improving the cybersecurity ecosystem. So I'm sure that there will be a lot of enforcement action in 2026. I don't know if I mentioned it, but there's a cybersecurity bill which is currently pending before Parliament, and it includes a lot of requirements. There's some there will be some financial burdens on cybersecurity providers. They'll be expected to contribute a portion of their revenue into a fund, a cybersecurity fund. The bill also would, has stronger enforcement powers, particularly for the Cybersecurity Authority. The bill also intends that there will be a lot of regulation on artificial intelligence, innovative products, blockchain. It's going to look at quantum computing. It would look at the Internet of Things. To ensure that these things are being deployed in a safe manner. So the bill has not, I think it's yet to go for cabinet approval. It's still circulating for stakeholder comments and what have you. It's facing a bit of a backlash. So it's a wait and see. We're waiting to see what the changes would look like when it's enforced. And we're happy to give you some further section where we have time to really talk through it. Okay, next slide, please. Okay.
Hi, Wendy, we're running a little bit long, so if we could do this next section, just highlights, please.
Okay, we'll do that. Okay, we'll run through it. Okay, next slide, please. Okay, so we've given you a bit of an overview of the IP framework. So Ghana is signatory to all these treaties that I don't need to mention them, the Paris Convention and all of that. We're signatory to these treaties. And this helps for one single application to be made in a place, and then for you to get multiple protection. In terms of our primary IP legislation, we have indicated all the different IP acts. We're happy to do further sessions where we'll take you through each one of them. Trademarks, next slide, please. So trademarks tends to be the area which we get a lot of requests for. We've indicated what some registrable signs, what registrable signs should include. So typically, if you're registering a mark, you need to ensure that your mark is distinctive, and then we also recommend that you conduct a search before you go ahead with the registration process. Next slide, please. So we've indicated what the process is. We've outlined the search, which is the requirement, and then we help with the application process. So this is just information for you to know. Next slide, please. Okay, I'll talk briefly about technology transfer agreements. So if a foreign entity enters into a technology transfer agreement with a company operating in Ghana, you're expected to register that technology transfer agreement with the Ghana Investment Promotion Center. So we've also outlined what the process for registration is. This is key because if you fail to do that, there would be, you can't remit funds that are, the funds that are to be paid for the services covered in the agreement. So you always have to ensure that if you have TTAs, and there are several, enforcement obligations when it comes to registering TTAs. This is another process that we also guide clients through quite well. Because of time, I would end it here. And then you can always reach out to us, and then we will give you all the additional information that you require. Thank you so much.
All right, thanks so much, Wendy. We actually did have a question from one of our participants tonight, and it was actually on registering trademarks and patents. Is there some benefit in registering with regional systems such as a repo compared with filing in individual countries? What's your recommendation there?
Our recommendation is to file under the repo system or any of the other systems, because it offers, as I mentioned, it offers you adequate protection across a number of member states, instead of just doing one national application and then you have to go into all these individual areas to do your registration. So it's always recommended to do, to do registrations under the different protocols.
And then in terms of protections, and again, this relates to perhaps trademarks, maybe also patents, but particularly in the e-commerce sector, what are some of the remedies that in this case, a Chinese party may be able to pursue if there is an infringement? Are there takedown mechanisms or other remedies?
Okay, I actually had it on my slide to present, but I had to cut it short because of time. So typically, when your rights are infringed, we would always advise that start with a cease and desist order. Once you start with a cease and desist order, you can get some. We do get results when we go through that process. You're able to settle, and then you're able to get the infringing party to stop using your trademark or your registered IP right. But if you do that and you're not getting results, then the next thing is to start, some legal action against the person. And there are so many orders that you can get in court. So you can get compensation orders, you can get damages, you can get preservation orders, which allows for the infringing material to be seized and preserved until the matter is heard till the end. You can get, orders for the material to be seized and destroyed because it infringes against your rights. So there are multiple ways of enforcing IP rights in Ghana. There are multiple ways of doing that.
And have you found that those are mostly effective, or sometimes you find that it's a question of whack-a-mole? You impose remedies on a certain producer, but then they change their name and change their location. You have to go and find them and then try to stop them again. What's the overall? Is there an overall strategy to avoid having these different infringement activities occurring in different places over different times?
Because registration under the protocol does not allow for one single form of enforcement across all member states, which would have been good, as we have the New York Convention. So assuming you had an award under the New York Convention, you could easily register it for enforcement in any of the member states. But with IP rights, it tends to be quite territorial. So except, Ghana has a relationship with a reciprocating country. If we do, then a judgment from that country can be registered here for enforcement. But otherwise, you would have to go through what your national laws are for enforcement, and then you take it, and then go to the other jurisdictions to enforce your rights as well. But there are ways of collaborating. So, sometimes you can get a judgment in another jurisdiction relating to those, those same rights. And then even if there's no reciprocating arrangement between Ghana and that other country, you can bring the judgment in here, and then it starts the basis for a new legal action. But it makes it will shorten the process, so you're not now going to have to really, you don't have the burden of really proving your case again, because it has been decided in another jurisdiction. So that helps as well.
All right. Well, thanks so much. I'd like to thank all of our presenters this evening. Ajibola, first from Nigeria, thank you so much. And then Achia and Wendy, thank you so much for your presentations on Ghana. Once again, we are so delighted to have our participants from ALN who are part of the SIPAC network. I think everyone who participated tonight and in prior webinars from our ALN friends, you can all tell that they're extraordinarily professional and also very personable. And we thank you for your very engaging presentations. And we say good night to everyone and thanks again.
Thank you so much.
Thank you so much, Robert. Thank you. Bye. Bye.
Bye.